This is breaking news.
The remarks from what the court would consider victims of the crime. Almost always there is no single appropriate sentence. Otherwise, the legislature would have designated a single appropriate sentence for every offense. The charges here are conspiracy to commit murder, which is a Class B felony. The legislature has set the sentencing range, not less than 1 year, nor more than 20 years, which means the legislature contemplated, in some instances, sentences of no more than a year, and in the same instance, sentences of 20 years. The legislature has given the judiciary a range. Conspiracy to tamper with physical evidence is a Class D felony, maximum 5 years. Tampering with physical evidence, a Class D felony, maximum 5 years. Hindering prosecution is a Class C felony, not less than 1 year nor more than 10 years. The court relies on what the law states and what the law allows to be proper considerations in setting a sentence. The court relies on the nature and circumstances of the offense, the history and background and character of the offender. After such consideration, the court turns to what are called the traditional purposes of sentencing: specific deterrence, general deterrence, punishment, incapacitation, rehabilitation, vocational or educational training, and medical treatment. Those factors are not all given equal weight depending on the nature and circumstances of the offense and the history, background, and character of the offender. The court does not take sides. If the court knew possibly any one of you and had a bond with any one of you, this court would not have tried that case. It's not the court's role to side or favor one side or another. Sentencing, in many ways, is a dispassionate exercise. The court has no bond with any individual who spoke today or any other individual involved in the case. The court cannot develop the passions that one side or the other has. In State versus Huey, that's 199 Connecticut 121 and 126, a 1986 case, the Connecticut Supreme Court held that the sentencing court may consider information that would be inadmissible at trial for the purpose of sentencing. That same court held that evidence of crimes for which the defendant was indicted but neither tried nor convicted may be considered. Well, the word indicted and the process of indictment is not generally employed in Connecticut. Essentially, that means where there has been a finding of probable cause, but there has been no trial or no conviction. Additionally, as a matter of due process, the court may consider information that has a minimum indicia of reliability. Now, that minimum indicia of reliability is not limited to unfavorable information. The court can consider favorable information that has a minimum indicia of reliability. The court certainly considers the victim impact statements. Every victim has the right to be heard before the court sentences a defendant. That's part of the Connecticut Victims' Bill of Rights, which is read every day in every courthouse here in Connecticut. The court would clarify what it perceives as perhaps a misconception of what the court's role is. The court does not deliberate with the jury. The court does not deliberate on the evidence at all. The court hears the evidence as the evidence comes into the record. So when you hear that the court has a view of the evidence, the court has no view of the evidence. What the court has is a verdict and what could have been the reasonable and logical inferences from the evidence that was adduced. The court would not know what the jury discussed over those many hours. What the court can find is this. It was clear during the jury charge, jury instructions, that the court instructed the jury that it may draw any reasonable and logical inferences from the facts found to have been proven. Based on the verdict, the jury could have found the following reasonable and logical inferences. Fotis Dulos was not home at 4 Jefferson Crossing the morning of May 24th when his wife was murdered, but the defendant said he was home. When the defendant admitted that he was not home, the defendant, who had been angry about Dulos's talking to other women, did not even ask him where he had been. The defendant, who was angry that he had visited his wife, did not ask him if he had visited her. In fact, the defendant, as the court remembers the evidence, didn't ask him anything. The jury could draw a reasonable and logical inference that the defendant knew where he was and knew what he was doing. The defendant said she saw Kent Mawhinney and Fotis Dulos together in the office at 4 Jefferson Crossing on the morning of May 24, but the defendant did not see Fotis Dulos and Kent Mawhinney in the office at 4 Jefferson Crossing on the morning of May 24. There was a phone call made to Dulos's phone, which Dulos left intentionally at 4 Jefferson Crossing. The defendant answered it and the jury could draw a reasonable and logical inference from all of the evidence that the defendant answered the phone to make it appear that Dulos took the call himself on the morning of May 24th at Fort Jefferson Crossing, when he was really on his way to or in New Canaan. When a police officer came to Fort Jefferson Crossing soon after the murder, the defendant did not even go to the door, even though her daughter, who was not home, may have been the subject of that conversation at the door. Now, it has been clear that the defendant cares deeply for her daughter. The jury could draw a reasonable and logical inference that the defendant did not go to the door because the defendant knew the reason the officer was there, to find out more about the disappearance of Jennifer Dulos. These are reasonable and logical inferences from the facts that were adduced in the case during the trial. The defendant traveled through a part of Hartford with Dulos as he dumps the bloody clothing of his wife. The jury could draw a reasonable and logical inference that on the same day, the defendant helped him pretend he was home in the morning, but in the evening accompanied him to get rid of the evidence. The defendant's DNA profile was found on one of the bags disposed of in Hartford. The jury could draw a reasonable and logical inference that the defendant helped dispose of the evidence knowingly. The jury could draw a reasonable and logical inference that the defendant helped Fotis Dulos clean up traces of evidence at 80 Mountain Spring Road because the defendant and Dulos were there together cleaning on the same day that Tacoma traveled to New Canaan. This is a flurry of irregular activity all on the same day. The jury could draw a reasonable and logical inference that the activities of that day were so irregular that the defendant could not possibly forget them in the span of 2 weeks. Even if the jurors individually had doubts about the defendant's guilt, each one of them ultimately concluded that their doubts were not reasonable. This is not a view of the court's view of the evidence. These are logical and reasonable inferences that the jury could have drawn. The court is going to talk a little about the philosophy of sentencing. Sentencing is not the product of the court's passions or prejudices. The court doesn't have a bond with anyone involved in the case. It's a dispassionate exercise. The court did not investigate the case. The court did not talk to the victims. The court has no conversation with the defendant or the defendant's family. So there are some questions that are age-old. Does the court, the sentencing court, adopt the public opprobrium, the indignation of the community? When does retribution turn into revenge? What's the role of empathy? Should the court exercise sympathy for one side or another? These are age-old questions. The court relies on what the law says. The court can consider the nature and circumstances of the offense, the history, background, and character of the offender. Every exercise is not an either-or exercise. Often, the good and the bad are true. What is the purpose of the court taking into consideration the victim impact statements? Is that only for the purpose of sympathy? The court uses the victim impact statements to assign, in its view, the proper weight to any one of those traditional purposes of sentencing. Sentencing is not arbitrary or capricious. It's not a matter of how the judge feels that day. The court wants to also address what has become, over the course of perhaps centuries, perhaps not, a cliche. Michelle Troconis' life is in your hands. Michelle Troconis' life is in her own hands. What Michelle Troconis decides to do today, tomorrow, and the next day is up to her. From what the court has heard, she has a great deal to offer. The court has no control over what her decisions will be. Her life is hers. The following sentences are going to run concurrently. On the count charging conspiracy to commit murder, 20 years execution suspended after 14 and a half years to serve, 5 years probation. Tampering with physical evidence, 5 years execution suspended after 4 years, 5 years probation. Conspiracy to tamper with physical evidence, 5 years execution suspended after 4 years, 5 years probation. The second count of tampering with physical evidence, 5 years execution suspended after 4 years, 5 years probation. Hindering prosecution, 5 years execution suspended after 4 years probation. After 4 years, rather, 5 years probation. Total effective sentence, 20 years, execution suspended after 14 and 1/2 years, 5 years probation. You will have an opportunity to challenge every finding that the jury made and every ruling that the court made. Madam Clerk, you can give the defendant her notice of right to appeal.
Judge, I'm going to orally state that Mr. Troconis does intend to appeal. I'm going to ask the court to set a reasonable appeal bond. I will state that the appeal bond that the court set was not something that Ms. Troconis or her family were able to meet. I'm asking for something more in line with what she had been released on bond for the last 5 years. I would note that after Your Honor went on vacation, the state asked for additional conditions, which included making her move to Connecticut and remain within the bounds of Connecticut. My position, Your Honor, is the court obviously took that into consideration when it set that high bond, that she was not a resident of Connecticut, because that's what the state had then argued. I'm asking that if she's going to be released, that the court set a $2 million bond, but with a condition that she reside in Connecticut and not leave without permission.
The court is going, well, counsel, the court is going to decline to set an appeal bond. It's not a constitutional right. Has the defendant signed the notice of right to appeal? We'll stand adjourned.
All rise. The Honorable Superior Court is now adjourned. Please exit the courtroom.
This has been breaking news.